In Arizona, real estate and employment agreement is the foundation of the relationship between a real estate broker and the salesperson or associate broker. This contract outlines duties, compensation, and legal obligations, ensuring compliance with state law and protecting both parties from misunderstandings or liability. Under ARS, paragraph 32.2151.02, and the Commissioner's Rules R4 28306. All real estate licensees must have a written employment agreement with the designated broker before engaging in any licensed activity. The purpose of this requirement is to ensure accountability, define the working relationship, and establish how compensation will be earned and paid. Without such an agreement, a salesperson or associate broker may not lawfully conduct real estate business on behalf of the broker. The Arizona Department of Real Estate, ADRE, requires that the employment agreement clearly specify whether the relationship is one of an employee or an independent contractor. This distinction affects not only tax treatment, but also liability and control. Most real estate professionals in Arizona operate as independent contractors. Under this arrangement, the broker does not control the salesperson's daily schedule or methods, but the salesperson must still comply with all laws, ethical standards, and brokerage policies. Key elements of the employment agreement. An employment agreement typically includes the nature of the relationship, employee, or independent contractor. Be written in clear and unambiguous language. The method and timing of compensation. The duration and terms of termination. The duties of both broker and licensee. The handling of listings, clients, and marketing materials upon termination. Compliance with the Arizona Revised Statutes and Commissioner's Rules. Be signed by all parties to the agreement. For example, consider a salesperson who lists a home in Mesa under their broker's supervision. If the salesperson leaves the brokerage before the home sells, the employment agreement must clarify whether they are entitled to a portion of the commission once the sale closes. Without this written agreement, disputes may arise, and the broker could be solely entitled to the compensation. Another critical point is that all commissions must be paid through the employing broker. ARS, paragraph 32.2155A, strictly prohibits a salesperson or associate broker from accepting compensation from anyone other than their employing broker. If an agent receives payment directly from a client or another broker, they could face disciplinary action by the ADRE, including suspension or revocation of their license. This rule reinforces the broker's supervisory role and accountability over all transactions conducted under their license. Compliance and supervision. Commissioner's Rule R428-1103 requires brokers to maintain reasonable supervision and control over the activities of their salespersons and associate brokers. The employment agreement is part of this supervisory framework. It defines expectations, reporting structures, and how marketing and client communications must be handled to comply with state law. For instance, a broker may require that all advertisements include the brokerage name in a prominent and readable manner. If a salesperson fails to do so, both the salesperson and broker could be held liable under ARS, paragraph 32.150A, 4, and 21 for misleading advertising. Therefore, employment agreements often reiterate these rules to ensure licensees understand their professional obligations. Termination of the agreement. Employment agreements must also specify how either party may terminate the relationship. Whether termination occurs voluntarily or through disciplinary action, it should outline procedures for handling active listings, pending escrows, and client files. The broker must immediately notify the ADRE upon termination, so the agent's license can be severed from the brokerage. For example, if an agent decides to transfer to another brokerage, they must submit a change form to the ADRE and have the new broker sign the hiring authorization. Until the ADRE updates the record, the agent cannot conduct licensed activities under the new brokerage. Real-world application A2023 case in Arizona. illustrated the importance of written employment agreements. A salesperson claimed unpaid commissions after leaving a brokerage. The court found that because the employment agreement clearly stated that only transactions closed before termination would be compensated, the broker had no further obligation to pay. This demonstrates how precise contract language can prevent disputes and protect both parties. Make sure that you read your employment agreement before you sign. Review summary. Employment agreements in Arizona. Real estate are more than administrative paperwork. They define the legal and professional framework between brokers and licensees. These agreements must be written, signed, and retained in the broker's records. They clarify whether a licensee is an independent contractor or employee, establish how compensation is earned and paid, and outline supervision and termination procedures. Compliance with ARS. Paragraph 32-215102. Paragraph 32-2155. In Commissioner's rules, such as R4-28-1103, ensures lawful practice, minimizes disputes, and upholds professional accountability within the brokerage. Discussion prompts and answers. Why is a written employment agreement required by Arizona law? Answer. To ensure both the broker and licensee understand their legal responsibilities, compensation terms, and the nature of their professional relationship. What are some potential risks if a salesperson operates without a valid employment agreement? Answer. The salesperson would be in violation of state law, could lose commission rights, and both the salesperson and broker may face ADRI disciplinary action. How does the independent contractor classification affect real estate professionals in Arizona? Answer. It allows flexibility in scheduling and business practices, but does not relieve the licensee from following all real estate laws, broker policies, and ethical obligations.